Now that the health care law has passed, several states are challenging it either through their attorney general offices or state legislatures. They claim the federal government is violating states' rights. Mark Rosen, a constitutional scholar and professor at Chicago Kent College of Law, is here to explain. Welcome to the show, Mark.
Thanks very much.
So at least 13 attorneys general are suing the federal government on grounds that it cannot force people to buy health insurance coverage. Now, you don't think states have a chance on this issue. Why is that?
Well, because I think it's fairly clear that the Congress has the power to require these kinds of things. Congress has never done exactly this before, but certainly Congress taxes people. You have to pay Social Security tax. States have the power to require people to buy insurance before they drive cars, for example. So I don't see this as being sort of significantly different from well-established powers that Congress has.
And this health care law isn't exactly forcing people to buy coverage, right?
That's correct, too. I mean, technically, it just fines people who don't. But I'd be willing to concede that, in effect, it almost requires people to buy insurance, but I don't see that as being constitutionally problematic.
Okay, then why do you think the 13 attorneys general filed this lawsuit if they probably don't have grounds to stand on?
That's a good question. Well, you know, partly they are, well, they could be trying to score some political points. Partly they're trying to spearhead perhaps a social movement. I mean, if they were actually first movers, mavericks who started a nationwide sentiment that Congress had really gone too far, then over time, conceivably, the Supreme Court could alter its understanding of Congress's powers and so forth. But in the short run, I don't know exactly. It's very hard to believe that they're going to be successful in court with their lawsuit.
And talking more about this sentiment, across the nation here, 38 state legislatures have proposed bills to limit, change, or oppose parts of the federal health care law. Some have failed to pass the state legislatures. Many others are still pending. Let's take a look at this. Virginia, Idaho, and Utah have already enacted new statutes saying that health care insurance coverage is not required. What do you think comes out of this?
Well, again, in the short run, I don't think much. But, you know, if there were two-thirds states that passed legislation, you know, they could require a constitutional convention, and then under Article 5 of the Constitution, if three-quarters of the states agreed, there could be an amendment to the Constitution. We've had amendments before. So, I mean, this could lead to something, but the only way it will is if this sparks, truly nationwide sentiment. I don't foresee that, but you never know.
So then basically these three states that have passed new statutes blocking that mandate, that's just symbolic. It has no teeth to it at all.
For sure. In the short run, it has no teeth because as long as the federal law is valid, I think it is under existing case law, then under the supremacy clause of the Constitution, states are required to give effect to the federal law.
And basically, the supremacy clause here makes federal law supreme, that everyone must follow it in the face of conflicting state law, so states cannot pass their own laws inconsistent with federal law.
That's right, and inconsistent, sort of broadly understood. So states can't pass a law that makes it difficult, that obstructs the federal law even, and some of these state bills would apparently do that.
And what about this? In the November 2010 ballot, Arizona voters go to the polls in November to vote on this issue that health insurance is not required. Now, how do you think that could play out?
Again, in the short run, it doesn't have any real effect as long as the federal law is valid. If what happens in Arizona in turn happens in 30 or 40 other states, then that potentially could lead to either a formal amendment of the Constitution, I don't foresee it, but that's possible, or informal amendment through altering the Supreme Court's jurisprudence. But those things take a long period of time. That's not to say what the states or the attorneys general are doing are flatly, wrong. There always have to be some first movers. It's just in the short run, it doesn't really have an effect. And, it might, in the end, just be followed.
All right, interesting conversation. I definitely learned a lot. Thank you very much. Mark Rosen,
Pleasure.
professor at the Chicago Kent College of Law.